Very good, Mr. Kessler, Mr. Walters. I see you're both in our virtual courtroom. We are ready when you are.
Good morning, Your Honors. May it please the court. Brian Kessler on behalf of the petitioner, Zachary Dieterle. And we're here before the court today on an order granting leave to assert punitive damages in an underlying civil case. In the court's order allowing the amendment to plead punitive damages, the court interpreted Florida Statute 768-72 to create a two-step process in whether or not a punitive damages claim should be allowed to go to a jury. Inherent in the first step, the judge created what I'll refer to as a pleading requirement, and then reserved the final determination as to whether or not there was a sufficient evidentiary basis to submit the matter to the jury. This is a substantial departure from Florida Statute 768-72 and the procedural requirements therein. The Henn case and its progeny detailed that a defendant, such as Mr. Dieterle in this case, has a positive legal right not to be subjected to financial worth discovery until the trial court has made an affirmative finding that there is a reasonable evidentiary basis for the punitive damages claim to go to the jury. So inherent in the Henn case and its progeny is this affirmative finding that there is sufficient evidence based on a reasonable showing that the matter can proceed on to the jury. But what the trial court, I believe Judge Sleet is talking, but he's on mute.
Judge Sleet, you're still on mute.
My apologies, but I appreciate your argument, but that the transcript does not bear that out, because you argued below with the first judge. It's clear under case law that a reasonable factual basis must support determination that the fact finder in the case will find not by preponderance of the evidence. The standard for punitive damages statute is clear and convincing. And the judge bought your argument that at the pleading stage, the judge must determine that the evidence adduced at that hearing, simply on the motion to amend to add pleading, the court must find that by clear and convincing evidence, the plaintiff can prove punitives. You argued that below.
Judge, I think what we have is a fundamental misunderstanding of what my argument truly was.
No, sir, this is exactly what you said.
No, I understand.
In black and white.
Yeah, as Judge Scale said in the third DCA case, ER Truck, in order to state a claim for punitive damages, the plaintiff must make a reasonable showing with proffered or record evidence that a trier of fact, based on clear and convincing evidence, would find the defendant guilty. That was my argument, is that I concede there has to be a reasonable showing, but inherent in that reasonable showing, there has to be a finding of recovery. So is there a reasonable showing that a plaintiff will recover the punitive damages? And inherent in that analysis, you have to look at subsection 2 of the statute. And in subsection 2, you have to look, what does it take to recover punitive damages? So in this case, when you look at subsection 1 and subsection 2 in tandem or hand in hand, it's clear that a reasonable showing has to be made by either proffered evidence or by evidence in the record that a plaintiff will be able to recover punitive damages. Well,
by clear and convincing evidence?
Exactly, because that's
then, sir, wait a minute, let me stop you. You would agree with me that you're at the pleading stage. You haven't even completed discovery. You're not having an evidentiary hearing where witnesses are testifying, where the court can apply the clear and convincing evidence standard at the pleading stage, are you?
I'm not suggesting that the court...
Well, then you're suggesting, what you're suggesting is that the court conduct a mini trial at the pleading stage and determine whether the plaintiff has proven by clear and convincing evidence that he or she can prove punitive damages in order to be able to plead it.
So, Judge, that's not what I'm suggesting. I'm suggesting that the proffered and record evidence has to create a reasonable showing that there will be a recovery of punitive damages. Inherent in that determination as to whether or not a reasonable showing has been made to warrant or support the recovery of punitive damages there has to be an underlying view of what is required to be able to recover punitive damages. And in subsection 2 of the statute, it's inherently clear that in order to recover punitive damages, that the clear and convincing standard applies. I submit to the court, and I concede that the clear and convincing standard is reserved for at trial.
The trial court would have to be clairvoyant to determine if the trier of fact could find the entitlement to punitive damages by clear and convincing evidence. They'd have to be clairvoyant at the pleading stage.
Well,
Subsection 2 applies to the trial, sir, because it starts out by saying a defendant may be held liable. That's the directed verdict standard.
So, Judge, in applying that interpretation of the statute, it goes against the Henn holding that a party has a substantive legal right to be free. So, in taking that interpretation of the statute, Judge, that we have a pleading, and at the pleading stage, we don't necessarily need to look at subsection 2, it creates the issue or the possibility that at the pleading stage or before trial, the trial judge allows the amendment to plead punitive damages. Financial net worth discovery is then conducted. And then when they arrive at trial, that the trial judge, it creates the possibility the trial judge may say, no, you didn't meet the sufficient standard. So therefore, it does not go to the jury. So what you've done
Yeah, but the rules of discovery still apply to punitive damages discovery. You're not entitled to trademark, copyright, trade secrets, privileged material. You're simply entitled to what is the company worth and what verdict could they afford to pay. So
sure, Judge.
Tell me why this statute is not fair to the pleader.
I'm not suggesting that the statute is not fair, Judge. I think the statute is fair in that it creates a process, a procedure that the court has to follow in an effort to fulfill its role as a gatekeeper to preclude financial worth discovery without a sufficient basis to warrant same. So I don't disagree that the statute is not fair. The statute is fair. What I'm saying in this case is that the judge failed to follow the proper procedure.
Well, I have a question. I'm trying to understand. There's two or three different interpretations of your position. The first is that in this case, the trial judge actually found there was a sufficient showing to support punitives. If he put a period in the order, we'd be here on that issue. But then he said something that is inherent in almost every ruling. Hey, we're going to defer until trial to see if they actually proved it. So if you take that out of the formula and say, yeah, I find this a sufficient basis, are you appealing that, or are you only appealing when it's tethered with, and we're going to defer to the trial to see if he's actually proved it? Because that's a judgment of that would be a judgment as a matter of law in your favor at trial, or it would go to a jury. But that's true of almost every ruling.
Sure, and I understand the question, Judge, and I would state that even though that was not, let's say that the second part of the order that I'm going to defer to trial to make a determination, I would still state that the order should be quashed because there was no finding as to a recovery, reasonable basis of recovery, number one. Number two, there was no discussion as to the intentional aspect of the counts in the complaint.
You're saying shooting the dog and killing the dog. How many times was the dog actually shot? Several times?
Judge, I believe that the record would show that it was only shot once.
One time. So correct, whether the shooting was justified at the point in time, you wanted the judge to rule as a matter of law that it was justified, therefore it can't be the basis for punitive damages. Am I understanding that argument?
No, I mean, I don't want to get into the weighing of the sufficiency of the evidence because I'll concede that it's not appropriate on appeal. But the argument before the lower court was that the dog was running at my client when my client shot the dog. So there were two people there at the scene, the plaintiff and the defendant. That's it. I hope that answers your question. But
No, I think you've answered the question. It's just a little bit confusing because the judge did something that you don't ordinarily see. He disagreed with the first judge's ruling, saying the first judge applied the wrong standard. And then he said, hey, there's enough to go to a jury, but if I'm wrong, we'll deal with it at trial, which to me, that's surplusage. But
Yeah, well, I would disagree with you that he made a finding that there was a sufficient evidentiary basis to go to the jury, Judge, because he explicitly stated in the order that the step 2 process under his interpretation of the statute involved a further weighing of the evidence before the matter was ultimately submitted to the jury.
let me just read you what I thought was a quote, but I could be wrong. That Jacobson established a reasonable basis to support granting leave to assert punitive damages for pleading purposes. Is that a correct recitation? And if so, is that wrong? Is that what you're saying?
That's a correct recitation, and it is wrong, Judge, because there is no distinction in the statute in interpreting the statute. There's no distinction between what is required at pleading and what is required at trial. I agree there is, but for purposes of pleading, you need to take subsection 1 and subsection 2 and read them together, which it's not an argument that lacks merit.
What case supports that proposition, sir? Because Hen doesn't get you there.
Sure,
Hen
Judge.
is completely procedurally distinguishable because the plaintiff didn't even file a motion for leave to amend. The plaintiff filed financial discovery and a motion for protective order was filed. That wasn't even done here. Judge Scales doesn't talk about incorporating a review of subsection 2 in any shape or form in here. So what case supports your position?
Yes, Judge, it's the ER truck case that was actually cited by the respondent. And for the record, it's 2020 Westlaw 1281021. And that's out of the 3rd DCA, an opinion that was filed on March 18th, 2020. And Judge Scales, in a concurring opinion, specifically states, and I quote, "In order to state a claim for punitive damages, the plaintiff must make a reasonable showing with proffered or record evidence that a trier of fact, based on clear and convincing evidence, could find the defendant guilty of intentional misconduct or gross negligence." That is the standard that was utilized by the predecessor judge in denying the initial motion for leave to amend, Judge. And that's the standard that the current judge disagrees with. So from a substantive.
And counsel, the problem I have with that is that doesn't seem to be consistent with the statute. And the Hen case out of the 4th DCA does what the trial judge in this case did, the successor, the second judge, and said, for purposes of pleading, there's enough here. And the statute breaks it down into 2 steps. What happens at the pleading stage and what happens when it goes to the fact finder. So I'm not sure that the 3rd DCA's discussion is consistent with the wording of the statute itself.
So Judge, if I may, if we look at subsection 1 of the statute, as you're all familiar with, in order to state a claim for punitive damages, there has to be a reasonable showing by evidence that would provide a reasonable basis for recovery. So before an amendment can be allowed asserting punitive damages, there has to be an affirmative finding that there's a reasonable basis for recovery of those damages. Absent from the trial court's
We agree with you
order.
so far. We agree with you so far, but subsection 2 clearly identifies a trier of fact. At the pleading stage, the court is not a trier of fact because there is no trial. You have no non-jury trial, nor do you have a jury trial. So subsection 2 applies to a trial, sir. Tell me how you have a trier of fact at the pleading stage.
I'm not trying to suggest that there is a trier of fact at the pleading stage, Judge. What I am trying to suggest is that before a trial court can allow leave to amend, there has to be an affirmative finding that you have recovery. And what defines recovery? So how can a trial court determine whether or not a reasonable basis for recovery exists before the trial court looks at what is ultimately required before one can prevail on punitive damages? And in doing so, they have to look at subsection 2 for guidance as to, well, what is ultimately required at trial to be able to recover punitive damages? And is there a reasonable showing by the plaintiff that meets that ability to recover? So I think you have to incorporate subsection 2 and the recovery aspect, what is required for recovery. It's incorporated because of the word recovery that is in subsection 1. Trial court has to make an affirmative finding as to recovery. What does it take?
You're at the 5-minute mark. Did you want to reserve any time for rebuttal?
I would like to reserve 5 minutes, Judge.
Very good.
Could you tell me the ER site once again, please?
Yes, Judge. It is 2020 Westlaw 1281021, and that is out of the 3rd district. It's 3D20-42.
Got it. Thank you very much.
Mr. Walters.
Very well. May it please the court, I'm here on behalf of the respondent Rodney Jacobson. For purposes of my presentation, I'll be referring to Mr. Jacobson as Jacobson and the petitioner, Mr. Dieterle, as Dieterle. The standard of review on a petition for writ of certiorari is whether there has been a departure from the essential requirements of the law. In Globe Newspaper Company versus King, the Florida Supreme Court had occasion to address what that means in the context of certiorari review of an order granting leave to plead punitive damages. The Florida Supreme Court held that the appellate court is limited to reviewing whether the trial judge complied with the procedural requirements of section 768.72. On a petition for certiorari, the appellate court may not review the sufficiency of the evidence supporting the order granting leave to plead punitive damages. The cases since Globe have refined that analysis and have made it clear that certiorari is only available when the record shows that a trial court applied the incorrect law. Certiorari is not available to remedy an incorrect application of the correct law. So what we have here is a petition for certiorari that's based upon an allegation that the petitioner believes that even though the trial judge applied the correct law, he did it in a fashion that was incorrect. That is beyond the scope of certiorari.
Well, let me ask you one question to understand the issue. The trial judge here was not required to make certain factual findings specific to this case to say that's enough to go to a jury or that's enough to support punitive damages, right? Is that
Correct.
true or false?
That is
So
correct.
what the trial judge did, generically speaking, I find as a factual basis to support punitive damages. That was the end of the story, and then tacked on the unnecessary language. And by the way, we'll deal with it at trial. If he doesn't prove his case, I'm going to take it back. But I'm assuming it's disputed as to whether or not lethal force was necessary to prevent this attack.
It absolutely is. And in
So
fact,
if it's a disputed issue of fact, what's a trial court to do? You say A, he says B. Normally a jury would sort that out. But if you say A and that meets the standard for punitive damages and there's no way to absolutely dispel it, that's not enough for the judge to say as a matter of law you haven't met your allegational proof.
and that's correct. And I think the legislature contemplated that very issue in the drafting of section 768.72, because the burden is on evidence proffered by the claimant. It doesn't say anything about evidence proffered by the defendant. And that's key because in this case, even though the judge said, well, I've reviewed the substantial evidence proffered by the plaintiff and the evidence proffered by the defendant, but that isn't even required under 768.72. If the proffer by the plaintiff is adequate to make a reasonable showing, and again, the standard for pleading purposes is reasonable showing, then it's clearly not an abuse of discretion for the judge.
Well, I mean, let's take a hypothetical which doesn't apply. If there was a legal standard or a law or a case law or a statute that says there's open season on pit bulls. If they make any aggressive maneuvers, you can shoot them on sight. We wouldn't be here, but we don't have that, right? It's still a burden of proof allegations. And
Correct.
that was met in this case, allegedly, right?
Correct.
Okay, that's all. That's my only question.
Getting back to the procedural nature of certiorari, and again, certiorari is essentially a due process test, and that's why it's a procedural analysis. There are three defined procedural requirements that can be reviewed on appellate review, on certiorari review. Number one, the movement has to attach a copy of the proposed amended completing to the motion for leave to amend. The movement must make a reasonable showing by serving a proffer or other evidence in the record at least 20 days ahead of time. And the trial court then must make an affirmative finding that the movement made a reasonable showing by evidence which would provide a reasonable basis to recover punitive damages. All of those things happened. Jacobson's proffer, which was again timely, included the deposition testimony of 11 witnesses, sworn answers to interrogatories, affidavits of 4 witnesses. Dieterle then, 4 days before the hearing, tendered his own deposition testimony and that of 9 witnesses. Both parties served lengthy memoranda of law. A hearing was held in which all of the parties were given an opportunity to present argument to the court. And the trial court entered a very thoughtful and detailed order, which exceeds 1,200 words in this case, explaining that there is a 2-tiered analysis, that for pleading purposes, a reasonable showing is what is required, that had been satisfied based upon the proffered evidence, and that he would continue to serve as a gatekeeper at trial to assure that competent and substantial evidence was adduced prior to submission to the jury. That is following the statute to the letter. There's really been nothing to support the allegations in the petition that the court didn't defer ruling until trial. He did state clearly and unequivocally that he had found that a reasonable basis had been pled. He talked about the standard and why he was applying it for pleading purposes, and there is no lack of clarity here. Nor did the trial court simply accept the allegations of the motion for leave to amend as true without requiring evidence. As I've mentioned, substantial evidence was adduced. And there is no requirement that at the pleading stage, the trial court indicate that it is applying a clear and convincing standard. None of the appellate cases that have addressed this issue have ever said at the pleading stage that you have to adduce clear and convincing evidence. Mention was made of a 3rd district case concurring opinion. We cited that case in our opinion because the holding of the court follows the law. The statement in the concurring opinion, I don't think was intended as an expression of any type of change in the law or even viewpoint on the issue. And it was a concurring opinion and not the opinion of the court. So it's not legal precedent. The argument that this court should evaluate the actual merits of Jacob's evidence, which is how I read the petition, essentially the argument boils down to the court made a mistake at the trial court level because our view of the facts is much different than his. That's clearly been rejected by every appellate court that has had that issue before it on a petition for writ of certiorari. I would direct the court's attention to this court's opinion in Stock Development LLC versus Ulrich. That case, the argument was made that the trial court had made a mistake because even though there was evidence adduced by the moving party in support of the motion for leave to amend to plead punitive damages, the petitioner thought that the court should have rejected that because it pertained to a corporation and events by a corporation, and that party had produced evidence showing that the corporation didn't exist. And the second DCA said, we can't review that. That's beyond the scope of our jurisdiction. We would ask that the court limit its review to the proper scope of a petition for certiorari and deny the petition.
Very good. Thank you, Mr. Walters. Mr. Kessler?
Thank you, Your Honors. First, I just want to point out that in the manner in which the order is drafted, that it presents the opportunity that somebody could be subjected to financial worth discovery. And I understand Judge Sleet's comments regarding that, but those are very personal in nature. And there is consistent findings that everybody has a substantial legal right not to have their financial history or their finances interfered with unless there's a legitimate reason to do so. Punitive damages being one of them, but that's why the statute is in place to ensure that there's a safeguard there. To allow financial discovery to occur prior to an affirmative finding that there's a reasonable basis that the claim should go to a jury subjects Mr. Dieterle, puts him in the position of having to turn over his financial worth discovery, having an opposing party know how much he's worth, with the uncertainty preparing for trial. And then there's uncertainty that when we get to trial, the trial court may say, no, you didn't establish a sufficient basis for evidence for punitive damages, and the issue never goes to the jury. At the pleading stage, there should be certainty with regard to whether or not somebody's going to be subjected to punitive damages, to allow not only preparation for trial, but to not risk the uncertainty that later on the claim doesn't go forward to the jury. So in closing, that would be my final comments. And I appreciate the court, but I welcome any questions from the court if they have any.
Very good, Mr. Kessler, Mr. Walters. Thank you both very much. That concludes this session of our oral arguments. We are adjourned, and you're welcome to leave the room or you'll be exited out. But thank you very much.
Thank you.
Judge.